Hi guys, and welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we'll continue with the series on partnerships, and we'll be talking about the obligations of the partners amongst themselves, or obligations amongst the partners inter se. Okay? So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Shout out to Rene Pulgar, Carlos Lim, Miggy Morales, and Shane Bernadette De Leon. Thank you guys for your assistance in this project, no? Okay, so let's begin, no? When we talk about the obligations of the partners amongst themselves, no, in relation to each other, we first have to begin with the nature of a partnership with a fixed term or a particular undertaking and a partnership at will. Okay? So let's just review it for a bit, no? So a partnership begins from the moment of the execution of the contract. Okay, remember, it's a contractual relation. So even if the contributions of the partners to the partnership have not yet been made, the form of the partnership already exists because, as I said, the partnership is a consensual contract, no? It is perfected by mere consent. However, of course, the partners may stipulate that the partnership will begin to exist from some other date for the commencement of the partnership relation. Okay? Now, in a sense, a partnership may have an unlimited duration. Okay, why? Because there is no time limit set by the law, unlike in a corporation under the old corporation law, no? Okay? There are no limits set for the existence of a partnership. But of course, the parties may, by stipulation, agree on a specific term. Okay? If the partnership is for a fixed term or for a particular undertaking, then the term has either expired or the undertaking has been completed and the partnership business is continued without an express agreement having been made. Okay? Then the rights and duties of the partners will remain the same as of termination as far as consistent with the principles of being a partnership at will. This is provided for, this rule, no, is provided for under Article 1785 of the Civil Code, no? So a continuation of the business without any settlement or liquidation of the partnership affairs, it is prima facie evidence of a continuation of the partnership. Okay? So if the parties expressly agree on a term or undertaking, the expiration of the term or the accomplishment of the undertaking will cause the automatic dissolution of the partnership. And if the partners continue the business, then the partnership with the fixed term is dissolved and a new partnership is created by implied agreement, which is a partnership at will. Okay? So when a partnership is created, there are several relations which are created by that contract of partnership. Okay? First is the relation among the parties themselves, no? Among the partners. Okay? The second relationship would be the relationship between the partners and the partnership itself. Remember that the partnership itself has a separate personality, no? Separate juridical personality. So there is a relationship between that entity of the partnership and the partners. A third relationship that is created, no, would be the relation between the partnership and the third persons, no, the strangers with whom it may contract or enter into obligations with. And the final relation would be the relationship between the partners themselves with those third persons with whom the partnership has contracted. Okay? I will be discussing the rules and the implications of each of those relations beginning with this episode and the succeeding episodes. But for today, we'll be discussing the relations among the parties themselves or among the partners. Okay? Now, when we talk about the relations among the parties themselves, now we're talking about the obligations of each partner to each other. And the foremost obligation is the obligation to observe good faith or the fiduciary duties to their co-partners. Now, when we talk about fiduciary duties, remember, no, that being in a fiduciary relationship involves the utmost good faith, no, and trust and confidence, okay? And we'll be discussing each of the obligations as we go on, okay? Now, I'll give you a brief overview. I will be listing all of the obligations, and then I'll discuss them after I list them, okay? First, we have the obligation with respect to contribution of property. Okay? Second, the obligation with respect to contribution of money, okay, or money which is converted by a partner to personal use. Third, the obligation not to engage in other business for himself. Okay? Fourth obligation of the partner is to contribute capital and, if necessary, additional capital. Okay? Fifth, the obligation of the managing partner who collects a debt, and the sixth, obligation of a partner who receives his share in the partnership credit. Okay? The next obligation would be the obligation of a partner for damages to the partnership, otherwise known as the duty of diligence. Okay? The next obligation would be the duty to render information. Next obligation is the obligation to account for any benefit and hold as trustee any personal profits or property. Okay? So those are the obligations of the partners amongst themselves. Now let's begin our discussion. Let's begin with the obligation with respect to contribution of property. Okay? First, the obligation to contribute property, no, is to contribute what has been promised. Okay? Remember, the parties in a partnership obligate themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits amongst themselves, no? So, the first duty, of course, is to contribute what has been promised. This is under Article 1786. Now, in case that person fails to contribute, the remedy is not rescission, okay? Not rescission, but the remedy is specific performance with damages and interest. This is following the case of Sancho versus Lizarraga, GR number L-33580. Okay? The next would be to warrant the property, no, in case of eviction. Okay, and under this same obligation would be the obligation to deliver the fruits of the property from the time that they should have been delivered without need of a demand. Okay, remember, the obligation to deliver the property carries with it the obligation to deliver the fruits. And take note that without these contributions, the partnership is useless. So time is of the essence. Failure to contribute makes the partner a debtor to the partnership, even in the absence of a demand. And that demand is not even necessary to put the partner in default, okay? So take note also, when the contribution is in the form of goods, the amount of the goods must be determined by the proper appraisal of its value at the time of contribution. Okay, at the time of contribution. This is following Article 1787. Okay? And why do we have to appraise that? Appraisal is necessary to determine how much has been contributed to determine the partner's share. Okay? The manner of appraisal can be agreed upon in the contract or in the absence of stipulation by experts chosen by the partners. And after appraisal, the partnership now bears the risk of loss and enjoys the benefits of subsequent change in value. In case of immovables, the appraisal will be made in the inventory, which should be attached. Take note of that. Okay? Under this same obligation, no, comes the obligation to preserve the property with the diligence of a good father of a family under 1163, no, pending delivery to the partnership. And finally, this carries also the obligation to indemnify for any damages caused by the retention of the property or delay in its contribution, even if no injury exists, okay? Because Article 1788, which provides for this rule, is absolute, okay? Now, when we were talking about the contribution, no? Let's talk a bit for the risk of loss of the things contributed. First, what if the thing is specific and determinate but not fungible, okay? So the risk of loss in this case is borne by the partner. Why? Because he remains the owner of the things. We follow the principle of res perit domino. Now, Manresa may have a differing opinion, but I believe that it is safer to simply follow res perit domino, that the owner bears the loss. Okay? Now, in case only the fruits or the use of the thing has been contributed and the thing is lost after delivery, then the partner still bears the loss. Why? Because he's still the owner of the thing. Okay, remember what was contributed was only the fruits or the use of the thing. Okay, now what if the thing is specific and determinate and the ownership and the thing has already been delivered to the partnership? Then the partnership bears the loss because, again, res perit domino, owner bears the loss. Since ownership has been transferred by delivery to the partnership will bear the loss. Take note further that the loss of that specific thing, okay, that loss may dissolve the partnership, okay? It depends, no? Now, what if the thing is a fungible thing, okay? The partnership will bear the loss, okay, the risk of loss, since the use is impossible without the things being consumed or impaired, okay? And in case of things which are contributed to the partnership to be sold, then the partnership bears the risk of loss because there was an intention to make the partnership the owner of those things. Finally, what about things which are brought and appraised in the inventory? Then of course, the partnership will bear the loss because there is an implied sale. It is implied through the intention to contribute to the partnership the price of the things contributed with an appraisal in the inventory. Okay? So that's the first obligation. Second obligation now would be obligations with respect to contribution of money and money which is converted by a partner to personal use. Okay? Now, of course, consistent with the first obligation, it is the duty of a partner to contribute on the due date the amount which he promised to give. Okay? This is also following 1788. Okay? And the liability of the partner to contribute that money, it arises from the commencement of the partnership. Okay? Unless, of course, it is otherwise stipulated. Okay? Now, also under this second obligation, no, would be the duty to reimburse any amount which the partner may have taken from the partnership coffers and converted to his own use. He got money and then he used it to buy something for his own personal use. Okay? The partner will be liable for that amount, and the liability begins from the time that he converted that amount to his own use. Now, what's the right of the partnership in this case? The partnership is entitled to demand only the amount converted, the interest, and the damages. But the partnership cannot avail of the profits derived by the partner from the use of the converted funds. Okay? Still under this second obligation includes the duty to pay the agreed or legal rate of interest in case of failure to pay the amount that the partner promised to contribute in due time. Okay? And finally, there is also the duty to indemnify the partnership for damages which is caused to the partnership due to the delay in giving the contribution. Okay, so here, from everything that I said, it is clear that a partner who undertakes to contribute a sum of money and fails to do so is already in default. Okay, he now becomes a debtor for the interest and damages from the time that he should have complied with his obligation. Is demand necessary? No. Demand is not necessary to place him in default. Why? Because the interest and damages accrue by operation of law. Okay? The double responsibility for interest and damages is for the reason that every partner is responsible to the partnership for damages suffered by the partnership through the fault of that partner. Okay? Now we can move on to the third obligation, okay, which is the obligation not to engage in other business for himself. Now let's divide this into two, because there are rules for industrial partners and there are rules for capitalist partners. Okay, let's first talk about the industrial partner. Remember that an industrial partner contributes his services or his industry or his work to the partnership, in which case he has to devote his time to the business of the partnership. As such, the industrial partner cannot engage in any business whatsoever for himself unless the partnership expressly permits him to do so. No, the parties agree. Okay? If the industrial partner engages in a business, let's say the industrial partner is a mechanic and the partnership is a car repair shop, can he put up a store selling drinks? No. Okay? He cannot do that. Any business at all is prohibited, okay? Because he has to devote his time and attention to the performance of his industry. So what if that partner still puts up that stall for drinks? Then the remedies of the other partners, whether they be capital or industrial partners, okay, would be that those partners who have suffered injury can claim the benefits which the industrial partner may have received. The purpose of this rule is simple, no? It's to prevent a conflict of interest and to ensure compliance by the industrial partner who must devote his time to the partnership, okay? Now, this rule on the industrial partner is found in 1789, okay? Now, the rule as to the capitalist partner is a little bit more relaxed, no? The capitalist partner is simply prohibited from engaging in an operation of a business which is of the same or similar kind in which the partnership is engaged, okay? So, if the partnership is selling lechon kawali, he cannot sell sisig, okay? So, that prohibition, no, carries with it an exception. Of course, the capitalist partner may be allowed if there is a stipulation to the contrary, meaning the other partners expressly agreed in writing. And what is the test to determine if there is a conflict of interest? The test is simply if there will be unfair competition. In either case, no, capitalist or industrial partner, just remember that the partner occupies a fiduciary position, no, a position imbued with trust and confidence, no. He occupies a fiduciary position with respect to his co-partners, and this imposes duties of utmost good faith. Therefore, the violator, no, the partner who violates these rules can be ousted, no, from the firm on the ground of loss of trust or confidence, which in turn, no, will lead to the dissolution of the firm. Okay? Now let's go to the fourth obligation, no, which is the obligation to contribute capital and, when necessary, additional capital. Okay? First, no, the contribution to the partnership, the contribution to the partnership capital, rather, no, it depends on the stipulation of the parties, what they may have agreed upon. And of course, the parties can agree that A will give a higher percentage than B, which is higher than C, etc. No? And in the absence of a stipulation, the presumption is that the contribution to capital will be in equal shares. Okay? Now, take note that that only holds for capitalist partners. The industrial partner cannot be required to contribute capital unless there is a stipulation to that effect. Okay? Now, let's talk about additional capital. Okay? So, the rule is, a partner is not bound to contribute additional capital except in case of imminent loss to the business. Okay? And there is no agreement to the contrary. Okay? Imminent loss and there is no agreement to the contrary. In which case, no, capitalist partners have an obligation, take note, ha, to contribute an additional share to save the venture. Okay? What if that capitalist partner refuses? Then the law says he must sell his share or his interest to the other partners. Okay? So in order for this rule to apply, of course, there must be an imminent loss to the business. Okay? Next is that, of course, majority of the capitalist partners are of the opinion that an additional contribution will be able to save the business. Okay? Then what happens next? There is a capitalist partner who deliberately refuses to contribute. It has to be deliberate without a valid reason. And it should not be a valid cause like financial difficulty. Okay? And finally, there has to be no agreement that even in the case of imminent loss, the partners will not be obliged to contribute. Okay? Now, also in this regard, please remember that the industrial partner, he is exempted from this rule. He is not bound to give additional capital. Why? Because they're already giving their entire industry. Okay? All their time for work is already given to the partnership. Okay? Now let's move on to the next obligation. The obligation of the managing partner who collects a debt. Now, this scenario contemplates a debtor who has a debt to the managing partner in his personal capacity and also has a debt to the partnership. Okay? So where a person, the debtor, is separately indebted to the partnership and to the managing partner at the same time, any sum received from that debtor should be applied, okay, to the two credits, to the partnership and to the managing partner in proportion to their amounts. Okay, even though the managing partner gives a receipt for his credit only. Okay, now the only time that it can be applied for payment in full, or at least the debt in full, is where the managing partner receives it entirely for the partnership, not for himself. Take note, priority is for the partnership. Okay? In which case, the whole sum shall be applied to the partnership credit only. Just in this rule, just think always, this is the key. Una, ang partnership. The partnership takes priority over the personal affairs of the managing partner. Okay? This is under 1792. Okay? The only instance when the debtor may choose to extinguish his liability to the managing partner, the only instance, is the debtor is given the right to apply payment of credit to that managing partner only if that debt is more onerous to the debtor than the debt owing to the partnership. It will be the debtor who has the choice, not the managing partner, because the duty of the managing partner is to put the interest of the partnership before his own. Okay? So take note also that the rule that I was just talking about only applies if the partner who is collecting the amount from the debtor is a managing partner. This rule will not apply to any other normal partner. Okay? And the purpose, of course, of this rule is to protect the interest of the partnership from being subordinated to the personal interests of the managing partner. Because as I said earlier, the managing partner has to put the interests of the partnership before his own. Okay? So in order for this rule to apply, there must be at least two debts. One to the partnership and one to the managing partner. And both debts, of course, must be demandable. So in this case, the managing partner who collects it should actually be the managing partner. He is authorized to manage the firm and he actually manages the partnership. Okay? Now let's go to the sixth obligation. Okay? Which is the obligation of the partner who receives his share in the partnership credit. Okay, in this case, in case of a partner who receives his share in the partnership credit, he shall be obliged, if in case the debtor becomes insolvent, the partner will be obliged to bring to the partnership capital what he has received, even though he may have given a receipt only for his share. Okay? he has to give it to the partnership. Again, because of the fiduciary duties, no, unahin ng partner ang interest ng partnership. Okay, always the partnership first. This rule is found in 1793. Okay, now the reason behind this rule is that when a debtor, no, becomes insolvent, then the debt in favor of the partnership becomes a bad debt, no? So it's a loss which must be borne by all the partners. So one partner cannot benefit to the detriment of the others. Okay? So in order for this rule to apply, no, there must have been at least one partner who has received, whether in whole or in part, no, his share of a partnership credit. Okay? And also the other partners, they should not have been able to collect their share as of yet, and then the debtor of the partnership becomes insolvent. In that case, the partner who has collected the debt from the debtor or even part of that debt should now give it to the partnership capital. Okay, because if there is a loss, all the partners should bear it equally. Okay? Take note also that this rule only applies before dissolution, meaning it can only apply during the time that the partnership capital still exists. Okay? Because upon dissolution and return to each partner of what they may have contributed, then the community of interest disappears. Okay? So the collecting partner no longer has to bring his share or what he has received to the partnership capital anymore, because the community of interest is already gone. Okay? Now let's go to the seventh obligation of the partners amongst themselves, which is the obligation of a partner for damages caused to the partnership, otherwise known as the duty of diligence. Under Article 1794 of the Civil Code, every partner is responsible to the partnership for damages suffered by the partnership through the fault of the partner. Now, in case that partner cannot compensate the partnership with the profits and benefits which he may have earned for the partnership by his industry, okay? He cannot do that, no? Again, every partner is responsible to the partnership for damages suffered by it through his fault. Okay? And he cannot say, no, I'm not liable for damages. I'll just pay you my what I received, yung profits and benefits. I'll just pay you that. No? He cannot relieve himself. Okay? The law expressly says that he cannot compensate the partnership with the profits and benefits which he may have earned for the partnership by his industry. Okay? The courts, however, no, may mitigate this, no? The courts may equitably lessen his responsibility. Okay? But the condition for mitigation is that the partners' extraordinary efforts in other activities of the partnership resulted in unusual profits, no? Extra profits, okay? Not in the normal course of business, okay? Now, how will we know how much damages should be paid or answered to by the partner? We will only know that after, during liquidation, no? Or even after liquidation. Okay? So, let's go now to the eighth obligation of the partners amongst themselves. It would be the duty to render information. And this is found in Article 1806. Okay? And it simply says that the partners shall render upon demand a true and full, they shall render upon demand, no, a true and full information of all things affecting the partnership, and they should give that to any partner or the legal representative of any deceased partner of any or of any partner under legal disability. Okay, simply put, no? Each partner has a duty to give information which affects the partnership, no? Legal and compliance, matters about transactions entered into, no? They have to give that information either to their co-partners directly or to the legal representatives, okay? And the final obligation, no, would be the obligation of a partner to account for any benefit and hold as a trustee any unauthorized personal profits or property. Okay? And this is found in Article 1807. This article says that every partner must account to the partnership for any benefit and hold as trustee, no? Account and hold as trustee for the partnership any profits derived by him without the consent of the other partners from any transaction connected with the formation, conduct, or liquidation of the partnership, or from any use by him of its property. Okay, as long as the partner receives something, no, this is how it is simply put, no, if the partner receives something which should properly pertain to the partnership, he holds that thing or money as a trustee with an obligation to give it to the partnership after. Okay, so here in this case, the partner cannot use or apply to his own benefit any partnership assets or the results of the knowledge or information which he has gained as a partner, and he cannot use those to the detriment of the partnership. Again, he cannot put his own interests ahead of the partnership, and any benefit which should accrue to the partnership should be for the partnership. He should not benefit from that alone. Okay, so from this case is accepted the situation where the taking of the thing or asset or money is done with the consent, of course, of all the partners. Remember, no, partnership is easy. Each partner is an agent of the other. So, of course, you should be doing things that will help your other partners. Remember, it's a fiduciary relationship. Okay? Trust and confidence. Do not put yourself ahead of the interests of the partnership itself or your co-partners. So, for example, let's say the partnership has a real property which has been mortgaged and then foreclosed. There is a single partner that takes the initiative to redeem that property. Does he become the owner of that property because he has redeemed it? No. Okay? That partner holds that redeemed property as a trustee. Okay? He holds it in trust for his co-partners, subject to his right, of course, to demand contribution for the amount which he may have spent to redeem that property. Okay? So the fiduciary duty of the partners prohibits him from acquiring title or interests which may be adverse to the partnership itself or to his co-partners. Now, this duty to account continues until the partnership is terminated, specifically the completion of winding up, as is the case with the other duties. No, once the partnership is terminated, then those duties terminate as well. Okay, now since there is a duty of the partner to hold the profits as a trustee, of course the partnership has a claim to specific property even if that partner subsequently becomes insolvent. Okay, now, in case this duty to account is breached, okay, then of course it is a ground to seek judicial dissolution of the partnership under Article 1831. Okay, so let's just recap again all the obligations of the partners amongst themselves, no, or the inter se, no. First, the obligation with respect to contribution of property. Second, obligations with respect to contribution of money and money converted to personal use. Third, the obligation not to engage in other business for himself. Fourth, the obligation to contribute capital and additional capital when necessary. Okay? Next, fifth, no, obligation of the managing partner who collects a debt. Sixth, the obligation of a partner who receives his share in the partnership credit. Okay? Seventh, obligation of a partner for damages to the partnership or the duty of diligence. Okay? Eighth, the duty to render information. And finally, the ninth, the obligation to account for any benefit and hold the same as trustee in favor of the partnership. Okay? So that's it for the obligations of the partners amongst themselves or obligations of the partners inter se. Okay? I hope you may have picked up a thing or two, and I hope to see you next time, guys. See you soon. Bye.